So, um, my name is Mark Cooper. I'm the director of the U.S. Department of Commerce here in Indianapolis. Many of you may know me uh, and be familiar with my uh, office. I'm not sure why it's transcribing in the chat. Hopefully I can get it to stop doing that. Well, either way. My name is Mark Cooper. I'm the director of the U.S. Department of Commerce in Indianapolis. My job is to help U.S. companies export and send their goods and services abroad. We are the frontline trade promotion organization and agency for the United States government. Our focus is small to medium-sized businesses, as many of you know, and many of you perhaps that are joining this call are familiar with our office through the years. Our objective has always been to create educational programming for Indiana's export community. And under those auspices, we work with something called the Indiana District Export Council, a group of Indiana businesses and service providers who are in fact commissioned by the Secretary of Commerce to promote exporting in Indiana and also to promote the education of Indiana's export community. We have joining us today, of course, our featured speaker, Lloyd Porter, who will introduce shortly. But I'd like to turn the microphone over to my friend and colleague and the chair of the Indiana District Export Council, Andrew Ranke, for some brief comments.
Thank you, Mark. I appreciate the opportunity to be with everyone again. This is our 5th scheduled Export Lunch and Learn webinar of the year. It's a new series IDEC launched in reaction to COVID, and it's a practice we'll probably be continuing past COVID due to the level of registries we've seen at these programs. And today I think we have registered at least over 60 from across Indiana and a few from other states. Today we'll be focusing on export compliance, process and procedure. It's a topic always high in demand and interest. A brief description about us, the Indiana DEC. We're a not-for-profit organization created under the auspices of the U.S. Department of Commerce. Each state in the union has at least one. We're comprised of members appointed by the U.S. Secretary of Commerce, as Mark mentioned, and we're employed in a variety of manufacturing, service, academic, government fields, all involved somehow with international trade and export promotion throughout the state of Indiana. We all serve to help answer trade questions and promote exporting as a viable way to grow revenue for companies, our state, and country. Joining us today are a few other members of the DEC. Raju Shintala, he's a senior advisor for the Indiana IEDC and president of Indiana India Business Council. Also, Christine Everett, director of programs for IU Kelley School of Business and IU Cyber. Mark Hubbs, director of international sales at Amatrol, and Ann Burkett on the national board for the District Export Council, joining from Washington. And of course, our own Lloyd Porter, who will be speaking soon. He's with the Indiana DEC. Thank you as always to our collaborative partners, IU Cyber, ISBC, the Indy Chamber, Exim Bank, and the US SBA Indiana office. Thank you, Lindsay Malachi. I think she's also joining us today. And I see Zach Greddy from the Indiana Department of Agriculture and Roger Hauer, InStep. Thank you for all joining us. I'd like to next introduce our speaker, Lloyd Porter. Lloyd is the Director for Global Trade Compliance and for the Cook Group, Cook Medical. As a member of Cook's Ethics and Compliance Leadership Team, Lloyd has globally responsibility for group trade compliance policy and programs, including export controls, trade sanctions, and import and customs compliance. Prior to his tenure with Cook, Lloyd served in trade compliance roles in the defense, aerospace, and laboratory equipment sectors, working extensively with classification of and export licensing of dual-use commodities and technology. Lloyd is a U.S. Customs broker and certified customs specialist. He's a valued member of our Indiana District Export Council for obvious reasons. He brings a wealth of information to this most challenging subject. We because of the volume of registries we have today and the complexity of topic, Lloyd's agreed to spend an extra 10 or so minutes with us after the 1 o'clock end date. So again, thank you to Lloyd Porter for his time. And Lloyd, the floor is yours.
Okay, well, certainly appreciate the kind remarks and introduction, Andy, and appreciate your support, Mark, as well, from the U.S. Commercial Service and Department of Commerce to support and make this program today possible. So, thanks very much. Let me share my screen and we'll get started. Okay, Andy, do we have our slide up today?
Mark, yes, we do.
Okay.
Yes, we do, Lloyd. We can see it just fine. The slide is good, and you are highlighted on the right-hand side. So
perfect. Okay. Well, again, thanks for this opportunity to present and talk about this very interesting and important topic to all of us who are engaged in facets of international trade. So let's take a look at our agenda today. So I've divided this presentation up into 5 different modules. We're going to first establish for our discussion today kind of fundamentally what is an export and what types of activities and commodities may be involved in exports. Then I intend to take a look at the really high-level overview of the United States export control framework or structure. And while we won't touch every possible facet or aspect, I think the areas we're going to focus on will likely cover the overwhelming majority of participants in our meeting today. Next, we'll focus some on what's formally referred to as the license determination process. How the steps you go through to assess whether a given transaction or proposed export is permissible and what those requirements might be to be compliant and successful with your transaction. Following that, I want to touch on the concepts around an export compliance program. This is an area I've found in my career that there's, can be a number of misunderstandings. And so I want to set the stage for what a integrated compliance program might look like in the types of roles and functions in your organization that might need to be involved in that. And then finally, we'll conclude with a brief discussion about possible resources for this area, and also what I refer to as response. And that's going to be geared toward, what if something goes wrong? Or what if in the course of our business activity, we become aware of something that might be a violation of an export control requirement? So that's our agenda, and we're going to get started.
Okay.
And as I said,
I'd just like to, Lloyd, before you continue, I just want to refer and make sure everybody has muted their mic. I'm trying to mute everyone, but please take a second to mute your mic if you're not speaking. Thank you.
Perfect. Thanks, Mark. Okay, let's talk about what an export is. And I started here at a very high level, a very generic definition, just pulled from a dictionary about an export. Well, fundamentally, something exported. It's maybe self-evident, but as it's defined, a commodity, okay, conveyed from one country to another for purposes of trade. I think that's an okay starting point, but for our purposes, I think we want to take it maybe to a higher level of precision, and that's what we're going to start to get into in this portion. Let's say an export is a transfer or release of a commodity from one country to another. And for physical commodities, an export occurs upon departure from a U.S. port of exit after export clearance has been completed, and we'll touch on that a bit further. The other thing I'd like to note here relative to exports of physical commodities, the mode of the transfer or the transport really isn't relevant. It could be an air shipment, a shipment by a marine vessel. It can also be something you send through the mail. Sometimes people overlook that. If you mail something to a foreign destination, that would constitute an export. And finally, things which a person may take with them to a foreign destination. Hand carry is sometimes what we refer to that in the business, and that could be physically in your hands with your person on the airplane, or it could be something contained in your baggage, whether it's accompanied baggage or unaccompanied, shipped separately. But let's talk about the categories of types of commodities that you might export. And we already referenced on the previous slide physical goods, and that's important. That probably comprises by volume and of course and by value the majority of exports, but it's not the only types of exports. And of course, physical commodities that are exported could be comprised by all types of things: machinery, food, livestock, mechanical systems, et cetera, et cetera. But another important category that sometimes gets overlooked, we're going to refer to broadly as information, is a type of commodity which can be exported. And within the respective regulations, the EAR or the ITAR, we'll define those. Those are referred to in a regulatory defined sense as either technology or technical data. So under the Export Administration regulations, information that's exported may be referred to as technology, whereas under the International Traffic in Arms regulations pertaining to military goods and equipment, the information would be referred to as technical data. But the concept of how those two terms would function is approximately synonymous. And the classic example there would be, a blueprint with information on it about how to make or machine, develop, design, produce a particular article. And now let's talk about services, which is another distinct category of an export commodity. Under the EAR or Export Administration regulations, services are encompassed within the bucket or the category of technology. However, under the military regulation, the ITAR, services have a unique defined term, and they're referred to as defense services. And services may be thought of as assistance. And one classic example here would be classroom instruction or training in the use of a machine or a system or a particular military platform would be an example of a defense service, which is involving fundamentally assistance or the transfer or export of a service as an export commodity. So let's say a few more words about this important area. I think physical commodities which are exported tend to be pretty intuitive to us, just from our day-to-day life in the globally integrated economy that we all now function in. So we have that. But when we talk about information and services, which frequently have intangible dimensions, these types of exports can occur in several different ways. It can occur through a delivery or a transfer or a release at a foreign location. So a technical support rep travels to a foreign country and provides assistance or information at that location. But it's also important to note that these kinds of exports can occur via all forms of electronic transfers. Email's common, FTP is not unusual. We could note that just the simple act of uploading information to unencrypted information to a cloud storage location could also comprise an export due to the location of the servers where that information at rest might reside. And there are other ones, but those are just a few examples. And then finally, I want to talk about a special kind of export, which involves a transfer of information or provision of services to a non-US person who happens to be in the United States. So in that type of situation, no border has physically been crossed, but information has been released and transferred. And for the purposes of US export control regulations, that would be considered an export to that recipient's home country. There are some differences in how the recipient's home country would be assessed under the two primary regulations, EAR and ITAR. It's a little bit outside the scope of what we'll get into today, but I'm just mentioning this as to give you the example of how this functions. And under the EAR, or Export Administration regulations, these kind of transfers that occur in the United States are referred to as deemed exports. So in deemed export transfers, as we mentioned, there's some type of a activity or a release of information or provision of service which occurs inside the territory of the U.S., not just the continental U.S. as portrayed in the graphic, but in that framework. And deemed exports here can occur in a number of different ways. We mentioned training as one example. Another one would be a facility tour. If you happen to be engaged in your operations in certain types of processes that themselves represent controlled technologies or controlled technical data, perhaps a manufacturing process or a repair and overhaul process, depending on the nature of what you do. Bringing a non-U.S. person, foreign visitor into your facility and giving them a tour, depending on how that's structured, could constitute some type of a export, release, or transfer. And in close connection with that, visual inspections of things, depending on what is being seen, could constitute export controlled transfers. Of course, we kind of mentioned the dimension of electronic access. And historically, the export control agencies have interpreted that if you have provided electronic access to a non-U.S. person, whether or not that person actually accessed information in some context, that is treated as an export has occurred, or it's presumed that the information has been accessed, whether or not that has actually occurred. And then finally, I think we referenced this a little bit too, discussions and presentations can constitute transfers of export controlled information. So it's important to keep all these possible modes of transfer in mind when you're considering I'm having a meeting or I'm having some type of a visit from non-U.S. persons. What's our activity? What's going to be discussed? What kind of access is going to occur? And are there issues surrounding technology or service transfers that we need to consider? Okay, let's talk about a different facet now. What is the scope? I mean, who primarily do U.S. export controls touch? Well, it's very broad. I think the United States still has the most broad application of export controls, in particular with respect to extraterritoriality. But although that is beginning to change in some of the other international export control regimes. But let's just note a key one. If you're a U.S. person, and by the way, we didn't define this earlier, but a U.S. person for export control purposes can be someone who's a U.S. citizen. It can be someone who's a lawful permanent resident, sometimes referred to as a green card holder. And a U.S. person can be an individual who's been granted asylum in the United States. So all those categories or classes of persons comprise U.S. persons. So non-U.S. persons would be anyone who's outside those three categories. Also subject to export controls would be any person in the United States, U.S. persons or otherwise, and any persons anywhere handling items which are either U.S. origin or products of U.S. origin technology. There is a de minimis level, a percentage of technology input below which it wouldn't be treated as a U.S. origin item, but just as a broad rule, let's just say U.S. origin items here. And then finally, owned or controlled subsidiaries of U.S. incorporated entities would also be subject to different facets of U.S. export controls. Now let's talk about some of the principal agencies. We're not going to cover every possible federal government agency and department which might touch export controls today, but we're going to focus on the primary ones, which again, address the majority of export activity that occurs from the United States. And at the top of the chart, we would say the United States Department of Commerce. And within the Department of Commerce, there's a sub-agency or a directorate known as the Bureau of Industry and Security, or BIS. Historically and previously, I believe that was referred to as the Bureau of Export Administration, sometimes abbreviated BXA. You may still see that, but today they're known as BIS, or Bureau of Industry and Security. Secondly, and importantly, under the U.S. Department of State is the Directorate of Defense Trade Controls, DDTC. Concerned with military commodities and exports and the regulation of those. And then I think we want to also note that the Department of the Treasury, the Office of Foreign Assets Controls, or OFAC. Treasury would be the agency that you would know more prominently associated with comprehensive destination-based sanctions, such as the comprehensive sanctions programs that are in place with Iran, North Korea, Syria, Venezuela, and other destinations. So that's one of the key areas of responsibility of OFAC, in addition to maintaining one of the important watch lists known as the Specially Designated Nationals list. Okay, so those are the principles that we're going to deal with today. I will note there are others, depending on, if you're working in certain areas of nuclear technology or nuclear commodities, either nuclear materials or equipment and technology that are used in, for example, civil nuclear electricity generation and things like this, you will probably have or be familiar with or know the U.S. Department of Energy and the Nuclear Regulatory Commission. But that's a very niche specialty area if you happen to be working with those types of commodities. So, in terms of the agency and its associated regulatory framework, the Department of Commerce regulations addressing U.S. export controls are the Export Administration Regulations, or EAR. Under the Department of State, we have what's called, for short, the ITAR, or International Traffic in Arms Regulations. And then under Treasury, there are a number of different regulatory programs. If you are dealing in sanctioned destinations, you will appreciate or come to appreciate these programs in OFAC are among the most complex, because they derive from a number of different laws that have evolved over time, and combined with various executive orders, and combined with regulatory frameworks and so on and so forth. So I've listed just a portion. This is just a very small representation of some of the different regulatory frameworks that roll up under OFAC's supervision relative primarily to sanctions programs. But for the most of the rest of this section, we'll be focusing on EAR and ITAR for the two regulatory frameworks. Now, it's very important. We're going to spend some time talking about jurisdiction and classification. So we start with jurisdiction. In other words, asking the question, which agency, has oversight for my commodity? And that leads us really to look at two things. Which regulation do I need to be consulting, depending on which agency regulates my export? And then secondly, within those respective regulations of the ITAR or the EAR, which control list should I be consulting? Where do I need to look to see if my commodity, my service, or my information is specifically called out as a listed control commodity? And under Department of State, the ITAR, the list is referred to as United States Munitions List, or USML. And under Commerce, we have the Commerce Control List, or CCL. Again, to acknowledge Department of Treasury is out there and has, if you will, a comprehensive and global oversight of certain aspects of export control activity focused on sanctions and sectoral or targeted sanctions, listed persons, and entities. In terms of the different control list structures, the United States Munitions List, and I'll refer to it from here on as USML, is focused on uniquely military commodities. It's organized into 21 different categories, which are designated by Roman numerals. It's just it's a feature, if you will, of the USML, which is distinct from other control list structures. And there's an emphasis, the types of commodities that you would find there, long emphasis on design intent, things which were specially designed for military applications. And by and large, although not exclusively, things which are uniquely military. There's really no civil application for most of what you'll find on the USML. For example, Abrams M1A1 tank. There's really not a civil application for that type of article, or an F-35 fighter aircraft. It doesn't have any civil role. It's uniquely military in its capability, design, and so forth. Contrast that with the Department of Commerce's control list, the CCL, which involves dual-use commodities. And that's a term that's closely associated with commerce and the commerce control list. That doesn't mean that commodities listed there only have two uses. They might have multiple uses beyond two different applications. But the suggestion or the implication of the dual use term is more of the nature. This commodity has a legitimate civilian application, but it also has capability to be repurposed to uses of concern, whether those be military, proliferation, human rights concerns, and many other dimensions that would be of concern from a national policy standpoint, terrorism, etc. Certain encryption items, for example, can be used for legitimate civilian purposes, but they can also be used by organized crime to conduct covert activity. That would be an example of something that might be considered and is likely listed as a dual-use commodity. Organizationally, the Commerce Control List is divided into 10 different categories, uniquely beginning with category 0. So you have categories 0 through 9, and then within each of those 10 categories, there's 5 subcategories. It's a different system of organization than you will find in the USML. And those 5 subcategories get into subcategory A, where you find end items, B, test, measurement, production, equipment. Category C involves materials like a bar of stainless steel stock. Category D gets into things such as software. And actually, there's a mistake on the slide. I'll acknowledge it's categories A through E because subcategory E is referring to technology, which can either be information or assistance within that control list. And the nature and character of the CCL is that you get into detailed technical and performance parameters. So when doing, say, classification work, which we'll talk about a little bit later in this presentation, it's very helpful that whoever's doing this work has to have a very solid, technical or engineering level of understanding sometimes to interpret and apply work within the Commerce Control List. And just a couple of quick excerpts there. We won't look at those in close detail, but you can even get a little sense, I think, of the different layout and structure of those two control lists. Now, I'd like to talk, put them side by side and take a look at the two different lists, the two different agencies, and how they work a little bit. And along the very bottom, I put what I call a spectrum bar from the far right hand, where it's more to the green color and increasing, if you will, in temperature, all the way to the far left hand of the slide, where you're over into the area or the category of the United States munitions list type of commodities. And I think the spectrum bar there can represent relative risk and complexity, and where you're more likely to find export licensing or export authorization requirements versus over at the far right hand of the spectrum. But I think it's important to note, under the Department of Commerce, if we look at the blue bar up at the top of the slide, the Department of Commerce regulation controls both dual-use items, which would appear on the Commerce Control List, but also items which are not listed, but are still subject to Department of Commerce jurisdiction for export control purposes. So a commodity that's subject to commerce jurisdiction but is not listed, it's not on the CCL, that doesn't mean it's uncontrolled. And I think that's one of the fundamental takeaways of partly of this slide, but hopefully that you can leave with today, is it's probably most helpful for most exporters not to think of any commodities as uncontrolled or unregulated, because there are actually very few things legally and strictly speaking that would fall into that category. And even with things that might be legally treated as uncontrolled, there might still be an export administration requirement upon export to complete a export filing or a reporting of that export. So the best thing operationally speaking, is just to understand that everything is subject to a requirement. Everything is subject to some type of control. As I think a working principle is how I would recommend that to you. Final comments on this slide. Under USML, munitions military, many of those items are going to be apparent. They're going to be uniquely military, and it's easy for us, I think, to consider what some of those examples might be from weapon systems, missiles, bombs, ammunition, ground and air and sea platforms, and so on and so forth. Over in the Department of Commerce territory on the Commerce Control List, you'll find a wide range of commodities spread out across those 10 categories. Different kinds of manufacturing equipment, such as laser cutting systems, lots of different chemicals, chemistry, chemical processing equipment. You'll see the biologics icon there, many different types of biologics, primarily bacteria and viruses are listed as dual-use items, as well as technology that's used in handling them or certain types of disinfection systems. You get into various other types of production equipment, communications equipment. I think we referenced all types of different computers may have a dual-use designation. And then on the far right, overall lower levels of export control concern, we could see just a few examples of those types of items. Now, let's spend a moment about the classification process. This is, I mean, after the principle of the operating principle of thinking and considering that really everything I might purpose to do from an export standpoint has a requirement. It's controlled in some fashion or it's regulated in some fashion. The second fundamental principle for us to consider today is that you have to understand how your commodity is classified. Which control list, does it fall subject to, or does it not fall subject to a control list, and it's therefore by default subject to the Department of Commerce as a unlisted item. So this is so fundamental. I think it's important we spend a little time here. And we'll talk about classification methods. So you might ask the question, am I required to go to the United States agency, the respective agencies, to get a formal classification for all my goods and services? The answer is no, you're not. You are entitled, you are allowed, and most organizations, do self-classification processes using their own expertise and knowledge of the product, perhaps in-house functional areas such as engineering to assist with the classification process. So that's completely legitimate. The next level, if you're going up the spectrum, would be to reach outside for someone who has expertise in this area, a consultant, or other an attorney who works in this area and is familiar with your particular industry's products and commodities. So the expert assistance, it can be very helpful in classification, especially if you're dealing in areas of complexity. And then finally, there are methodologies and vehicles and mechanisms to obtain a United States government agency position on your product. And I want to talk about two of those different processes. The first one is the commodity jurisdiction request, sometimes referred to as a CJ for short. And the Department of State actually has sole jurisdiction to make commodity jurisdiction decisions. So, for example, if you have a new machine you've invented, and let's say it does have some applications to sell to a military end user, but it could also be used in civil or commercial industry settings, you might be asking the question, is my article subject to State Department controls for export purposes, or is it subject to Commerce Department controls under the EAR? Well, the starting point, before you even take a look at which, where can I find this potentially on a classification list, would be submitting a formal commodity jurisdiction request to the State Department. And that's now a fully electronic process through their portals. It used to be paper-based a long time ago, but it's now an electronic process. And the State Department would get the first opportunity to rule on that. After that, if they determine that your article is subject to ITAR controls, under the State Department jurisdiction, most likely they're going to return to you a position also on where it falls within the USML, the United States Munitions List. And keeping in mind there, if your commodity is subject to State Department controls, it is going to be somewhere on the USML. Everything subject to State Department has an entry, if you will, a placement on the Commerce Control List. That's a little bit different than commerce commodities, which there are some which are listed on the Commerce Control List and others which are not listed. So it's a little bit different framework there. And then following that to the next step, if you get a position that your article is not subject to State Department control and you need to refer to the Department of Commerce, the Commerce Department also has a formal classification request process by which you can submit technical specifications, information about your product or your service or your information technology, and they will assist you with making a determination if it appears on the Commerce Control List and where it is so listed. So that's the fundamental outline of the classification process. So it's jurisdiction first, is it State Department versus Commerce Department, and then classification in the respective list. I think I already mentioned this on the previous slide. Everything subject to State Department does have a USML category listing designation, but on the commerce side of the house, only some commodities will be CCL listed, not all. Probably the majority of commodities are not, but within the Commerce Control List, you will have an awful lot of technical dual-use commodities listed. Okay, now let's go on to the next module in our presentation today, known as license determination. So this process really should answer three different questions. One, can I do this at all? I mean, is this even permissible with or without a license? Am I allowed to do this? Second question, if I am allowed to do this, am I required to possess a specific government authorization before I conduct this export activity? And an export authorization might take several different forms, which we'll touch on in a later slide. But do I have to have something, a permission slip, if you will, before I begin? And then finally, license determination also helps us understand, in addition to do I have an authorization requirement, what other responsibilities may I have in the transaction? So let's unpack this a little bit. And the way I like to unpack or determine license determination, and these really in a little bit different format, these 5 questions are outlined by the Department of Commerce, export control guidance and framework. So I mean, this isn't unique. I didn't invent this, but these are the things to keep in mind, because if you omit any of these questions or you don't get a good answer to one of these 5 questions, you could make a mistake in your proceeding with your activity, or you might refrain from an activity that's otherwise permissible. So that's why it's important that we kind of have a comprehensive framework for making this determination. So 5 questions for answering do I need a license? What is it? What type of article is it? We've really been talking a lot about what is it in terms of jurisdiction and classification. So how's my commodity regulated, and does it appear on a control list? Second question, where is it going? And we're asking the question, what country destination? Because we may have a roadblock there depending on the ultimate destination of this export. Next, who's going to receive it? This is what I call the end user question. Not necessarily who will handle it along the way, although with some commodities that's very important. You have to have those answers as well, but ultimately, who's the end user recipient? Fourth question, what do they want to do with it? And that answers like, what is the end use? So when we talk about export controls, frequently we get into the question of end use. And then finally, what other activities is the recipient engaged in, and with whom? This is almost like getting into due diligence and the company your recipient keeps and things like this. Kind of separate from the other 4 framework questions, but vitally important. So let's unpack these and quickly step through. So for the first one, what is it? As we mentioned, it's a jurisdiction and classification of your export commodity. And this helps us determine, of course, the applicable regulatory framework and do we have an authorization requirement? In other words, do I have to request and obtain an approved license before I proceed? And other kinds of authorizations that aren't licenses are comprised by things referred to as exemptions or exceptions. Okay, and those come into play when there's an affirmative license requirement, but if you meet certain conditions under certain circumstances, you're allowed to, if you will, self-certify that I meet the terms of this exemption or I meet the terms of this license exception, and you're permitted then to proceed. And of course, finally, you may reach the conclusion as you go through understanding the classification of your commodity that based on its destination and the answers to all the other questions, there is no license requirement before I proceed. Okay. Second question, where is it going? We talked about it. It's the country destination. And this helps us identify whether there are any possible OFAC sanctions controls. For example, exports to Iran are comprehensively sanctioned. It doesn't mean maybe impossible, but many types of commodities you would not be successful in obtaining an export license. There are exceptions in most sanctioned destinations for medicine, medical devices, food, in some cases, replacement parts for civilian aviation to ensure safety of aviation in those areas and things like that. But it's important to understand if there's any comprehensive destination-based sanctions. And also, if you happen to be working in the military controls area, there may be certain countries that are what are referred to as prescribed under Part 126 of that regulation, which is to say, you don't need to bother asking for a license. For example, you are not going to get a license for an ITAR control commodity going to China. Okay, they're not going to grant you a license, and they tell you that as well as a list of other destinations within that regulation. So that's why it's important to understand where it's going, and moreover, where is it ultimately going? If you're dealing with, for example, a distribution partner or some other type of a broker or intermediary, you really have to answer the destination question based on the article's ultimate destination. This helps us determine, what our license requirements may or may not be. Okay, license determination process, question 3. Who's going to receive it? Who's the end user? We have to know this information, and this supports some of the critical watch list, restrictions list, and sanctions list screening processes, which you need to do, at a customer account level and at a recipient level if it's shipping to a different, address than, the invoice or billing address for your customer. This supports know your customer due diligence, which is a really a key pillar to export controls. It's not merely is my item listed or does it require a license, but also are there any other reasons I should be concerned about dealing with this customer? We'll unpack due diligence just a few steps further. While I'm on this topic of watch list screening, there are a number of different commercial service providers that provide meta screening tools, where in one search you can put a name of a company in or a name of a person and search multiple lists all at once. The United States government also provides a consolidated screening list. It may not contain as many lists as some of the commercial providers, but it is available to you. And if you do a web search on consolidated screening list, I think you'll be able to quickly find this link. So it is not hard to find, and I think it's part of the International Trade Administration ITA website is where you will find that list. And it's a good search tool, and it can be considered reliable. Okay, next question. Why does the recipient want the item? What are they going to do with it when they get it? We have to have an understanding of that. With some items, it's pretty self-evident. A sack of flour, is probably going to be used to make bread or something like this. So certain commodities, the end use is either intrinsic to that commodity, and doesn't require a lot of due diligence to uncover. Other types of machinery, laser systems, vacuum chambers, sterilization equipment, there are many more questions to be asked in the end use arena. What types of processes, what activities may this end user be involved in? So you have to explore end use in a little more detail. And of course, if you're having to be dealing with a distributor in a foreign country who resells equipment either within that country or other places, depending on the control list status of your export commodity, uncovering the end use may require the distributor to divulge who their customer is and what would be the end use application there. In fact, many, if not all, export license applications are going to require a fairly detailed explanation of end use for the respective commodities. This also supports compliance with what are referred to as the general prohibitions under the EAR and helps us with the due diligence questions, such as, is the stated end use consistent with the item's capabilities? Okay, the final question. In what other activities is the end user or the recipient engaged, and with whom? I like to call this the red flag check. Due diligence and understanding who your customer is, knowing your customer, does ask the question about the end use being consistent with the end user identity. And the textbook case that you will come across in the EAR export compliance seminars here, one example would be if the stated end user recipient was a bakery in Egypt and they're ordering from you a very high-tech machining tool, a 5-axis lathe with very tight machining tolerances. I mean, this is an example that's so obvious it's ridiculous, but that would be the example of, hey, wait a second, what does a bakery need with a high precision machinery tool? That's at least doesn't seem consistent with their stated activities. I've had more subtle examples in my career, and I've had examples such as a fishing tackle company attempting to order from my organization a particular aircraft platform antenna that happened to be used for navigation purposes that are unique to military aircraft. So, we had an obvious red flag there. When we have a red flag that arises in the course of a prospective export, it doesn't absolutely mean we can't proceed, but it does place upon us as U.S. exporters the obligation to attempt to resolve that red flag. And if further information is made available to us that explains it in a satisfactory manner, then usually we're permitted to proceed, but we need to have that documented and on file. And if the answers don't square up, or we don't get answers, or the line goes dead, that's likely a sign this wasn't a good transaction and wouldn't have been authorized. Okay, let's talk here in our final slides a little bit about the closing topics. What's an export compliance program? Well, is an export compliance program a policy, a manual, someone who's a designated point of contact? Many, if not all of us, will either be that person or will know who that person is in our organization. Maybe you have a formal trade compliance program manager, or perhaps you're aware, if you're in this area, you're registered as an ITAR goods manufacturer or perhaps an exporter. All of these things are going to probably be in your totality of your program, but by themselves would not constitute a program. So before we speak a little bit about an export compliance program, I want to step it back to even just a more generic, higher level, just about any type of compliance program that functions in any different area, whether it's trade controls, accounting and finance controls, SEC, hazardous materials, OSHA, whatever. These would be examples of what are sometimes referred to as the 7 elements of an effective compliance program. There's leadership, there's something in writing. This isn't just a practice we have. We do have policies and procedures, for example. Ongoing training and education of the people involved. We do have communication and awareness, monitoring, auditing in the organization, investigation response if something goes wrong, and then really kind of founded upon a concept of we're always updating our program. We don't just create it once and it was really good in 2005, but we haven't touched it since, and wait, the regulations has changed. Wait, export control reform has happened, and some of my things that used to be ITAR controlled have now moved to the Commerce Control List, for example. So ongoing improvement or continuous improvement is really a foundational keystone of an integrated program. So speaking of an integrated program, every trade controls program is going to need to have an overarching policy authority, that covers everyone in your organization. And that might be placed in different ways, and it might vary how an organization approaches it, but it's going to have a founding principle that we're going to be compliant with U.S. export controls. Then that's going to spread down into distributed functional ownership. And again, this will vary depending on the scale, the scope, the sophistication of your organization, and frankly, what types of commodities you transact in an international market, okay? But examples of functional areas that might participate would include engineering, finance, supply chain, procurement within supply chain, customer service, people who are, doing order management and shipping transactions, perhaps. Also sales and business development, just as examples. And then it flows down into each of these areas, not just the example I have where supply chain, is bracketed and has within supply chain functional level procedures, processes, work instructions, what types of records need to be retained from an export control standpoint. It's a very important facet. Are you supervising your forwarder, your freight forwarder who is conducting exports and assisting you in that way as an agent? Are you receiving back from them required export control filings, paperwork? Are they administering your export license properly and presenting it to the correct agencies or to customs, things like that. And then finally, again, depending on the structure of your program, internal audit might be within one or more of these areas, a periodic program of validating our activities and what we've been doing. Remember, the goal is an integrated program, not one person sitting in a room. It's called the Export Compliance Manager. That's important, and you may need that, and that may be vital, but you got to have a process and a policy that flows throughout your organization and pulls the pieces together. Because in the order, build, ship, collect cycle, all of those can have touch points on export controls, and they all need to be properly integrated and structured. Finally, resources. There's a wealth of good information on the U.S. government websites. I do commend to you Bureau of Industry and Security. It's easy to find the website. Similarly, if you're in military areas of practice, you're going to be well familiar or need to be familiar with the DDTC, Directorate of Defense Trade Controls website, and there are good resources and information there. Don't overlook the value, the incredible value of outside counsel and a law firm that has a trade law specialization that spends time working in these areas. They can become very specialized depending on the nature of your industry. People who, primarily serve military and defense contractors, others who work in the Department of Commerce and dual use arena. It can be very valuable and important. There are a number of government agency seminars, both in person and virtual. The quality has really been increasing in my perspective over the years, and I would highly commend those to you, as well as many private seminar providers. Your freight forwarder and logistics provider can also provide you with assistance. And finally, there are consultants and trade organizations which will provide educational opportunities and provide consulting resource for you. And then finally, what I want to get to is, what do we do if something goes wrong? Well, if it's in process, do your best. If you realize or suspect or think there may be a violation occurring or about to occur, is to stop the shipment, stop the transfer, the release, the meeting, the activity, or whatever. Of course, basic principle, maintain records. You're going to want to notify internal leadership. If you have internal general counsel, they need to be apprised. And then you'll have various considerations. Do we need to retain external counsel? What corrective actions need to be implemented? What's the relative level of severity of this occurrence? And then you may, in conjunction with internal and external counsel, evaluate whether a self-disclosure to the respective agency or agencies would be in your best interest. In some cases, there's a significant penalty or fine mitigations that can be conferred through qualifying self-disclosures. So that's really something I would encourage to be part of your mix. And with that, we're going to wrap this up today. I really appreciate your attention, and of course, I appreciate the opportunity to present. And I'll turn it back over to Mark and Andy. If we have any after discussion, I'm glad to participate and support that. So thanks again.
Well, I thank you, Lloyd. That was fantastic. Very informative and detailed presentation. There's a lot more, obviously, you can say about this topic, but we're in an hour, and so
Yeah, sure.
I think that was really fantastic. Andy, do you want to start with any questions that you have?
Sure. And I don't know if anybody else has written into the
I didn't
chat.
see anything in the chat. I was looking,
Okay.
so I didn't see anything right now. If you don't have one, I have a question always.
Well, I do have one, and I know you and I always do this. This is fantastic. Again, Lloyd, thank you so much for your time.
Sure.
Excellent presentation. And it's something maybe we ought to be doing on a regular basis, bringing this kind of level of information to Indiana companies. But you mentioned earlier in your presentation that it either falls under ITAR state,
Yes.
or it falls under dual use. It's on the Commerce control list, and say a company is going and doing its due diligence.
Yes.
They have a new product, and they know they need to be looking at the Commerce control list. They look at the alphabet list. They start looking at start looking, and then they don't stop there. They start looking at those categories and
Sure.
chapters. And they get a rough idea. It's dual use.
Yes.
And I get these questions asked all the time. They think they know the Commerce control number, but they're not exactly sure. And in your presentation, you mentioned sometimes beginning with state to asking for guidance, other times looking at Commerce, BIS. If you know it's a dual use item,
yes.
The way I understand it, you can start there and ask Commerce through SNAP-R, BIS, if they, what the export commodity classification number is, and they'll
Correct.
tell you. And if they have a question, if it's under ITAR, they'll bring in ITAR at that point, state, for their review. So is it good sometimes to start with the SNAP-R with BIS if it's a dual use item?
Yeah, that's a great question, Andy, and I appreciate the opportunity to bring a little clarification to that. I think the answer to the question is if you have uncertainty about the jurisdiction, or you think there's a possible military application, then in that case, I would definitely begin with the State Department commodity jurisdiction request. Okay, that's really what that process is designed for. However, if as you prefaced in your question, if you're confident that you're somewhere in the Department of Commerce, then yes, definitely, I think you're totally free to move forward, with a SNAP-R commodity classification request submission. Absolutely. But one of the interesting things you will find, though, when you receive back, and I haven't had the occasion to do one in a pretty good period of time, but when we used to get our Commerce commodity classification request return, they would put a disclaimer at the footer that says, this doesn't necessarily mean if you haven't given us all the information here, if you're uncertain about the jurisdiction, you need to go talk to the State Department. So there's always a kind of a cautionary disclaimer there that their commodity classification determination is contingent on the jurisdiction being correct. And so that's the thing you have to keep in mind there.
Okay. Thank you, Lloyd. And I do, before we jump into another question, I do want to say we are at 1 o'clock. We're going over for questions, and I'd like to remind everybody that our next program, if you've got a hard stop at 1 o'clock, our next program's November 18th. It'll focus on green technology, following what's going on with the UN climate conference in Glasgow at the same time in November. So we'll post information about the next export webinar, which is in November. Mark, back to you.
Okay. Thank you very much, Andy, and thank you very much, Lloyd. Just one quick question before we adjourn here. I think folks, obviously lunch hour, but you had mentioned about the jurisdictional request. Some clients had mentioned to me in the past that there was a cost on the CJ request from the Defense Trade Controls versus it being free on the commerce side? Have you seen that?
You know, that's an interesting question, and this is what I believe to be the answer. And I haven't confirmed this recently, Mark, but I think you are permitted to submit a CJ request without a fee structure. I think what may happen is that if you are in the business of producing a military article, you are required then at the first instance to be registered as either a manufacturer or exporter with State Department. And there is a fee structure around that, okay?
Yeah.
The registration does have a fee requirement. Yes. But I think if you're starting out and you've never been in that arena and you just need to get your first commodity jurisdiction position, last I recalled, there wasn't a fee associated with that. Now, that may have changed somewhat recently, but that's my recollection.
Yeah, I think for our clients and folks on the call that are still left, just check that out, because sometimes I've recommended actually seeing what commerce, how their jurisdiction falls, because it is free. Right. And then if you are really unsure on the military application, go to get a CJ, because there may be a cost. Unless you, of course, know that it's a military thing and you're going to have to pay, right? Just like that. But just something to be aware of, especially for small companies where every dollar counts. So, yes. All right. Thanks for putting that in the chat, Andy, about the next event. We want to be respectful of everyone's time. We want to say thank you to everyone for joining us today. I don't see any other questions in the chat at this point. Lloyd, thank you so much as a DEC member and as a expert on this topic from Cook. We appreciate your comments and your knowledge about this. Thanks so much. And thanks for everyone for joining. And Andy, any final words as we close?
Nope, none. Thank you again, Lloyd, for your excellent presentation. Mark, as always, thanks for your partnership.
Okay. Everyone have a good day.
All right. Thanks very much. Bye-bye.
Bye now.
Thanks.